Hello and welcome to Unreal Life. That's the YouTube channel, and today we're doing one for FLAST, which is Family Law Australia Support and Training. May was a big month for family law insofar as there's new laws that have come into effect as of the 6th of May. And I guess today I'm just want to have a quick look and see what's happened in May in the court. We're going to start off. I'm just here in Ausley, and there's three primary jurisdictions that we're talking about: the Federal Circuit and Family Court of Australia, Division 1 Appellate Jurisdiction, the First Instance, and Division 2 Family Law jurisdiction here. So we're going to look at all three of those, and if I just open in a new window each of those so you can see what cases we're going to have a look at. So the first one that we're going to look at here is just in the appellate jurisdiction, so that's where I'm going to start off. Okay, so the first case that we've got is a 66 paragraph judgment, Saha and Lahiri. Now, the way I would do this, and I'm showing this to you because, you know, in the past, this whole process that I'm going to go through now would have taken days, literally days. And I'm here showcasing some of the power of AI as well in this whole process. Okay, so this is the case of Saha and Lahiri. As I was saying, in the past, this would have taken days to do what we're going to do today. I'm going to just copy that link here and go straight into GPT. In this case, I'm not even using the FLAST AI engine. I'm using OpenAI's ChatGPT for this particular purpose. We are running it under a FLAST GPT, which gives it a bit more context, but beyond that, this is the GPT. So it starts off with a prompt. So go to this website. So it starts off with a prompt. Go to this website and give me a detailed IRAC analysis showing the facts, issues, applicable law, highlight any law that was discussed, analysis, and provide details of any case law discussed, show reasoning for the decision, and take home lesson learned. So that's my prompt, and with a prompt like that, when I send this off, AI is searching the web, it's found the site, it's doing an IRAC analysis here, and I'm going to just let it go because it only takes a few seconds, so I might as well let it finish. So at the bottom, it's giving us a full link to the judgment. Take home lesson is an enforcement orders in family law can be interlocutory, and challenging them requires demonstrating substantial doubt and injustice in the original decision. The jurisdiction of the court in family law matters is broad, including enforcement actions involving property, possession, and costs. Wow, interesting. So, reasoning for the decision, the court found no merit in the wife's grounds for appeal. The orders were confirmed as interlocutory, and the jurisdiction of the court was upheld. There was no evidence of substantial injustice, and costs were awarded against the wife. So that we're going straight to take-home lesson learned and the reasoning for the decision. Obviously, it went against the wife in this case. Here's the case law that was cited, and the analysis shows that there's a difference between interlocutory and final orders. That was part of the reasoning in this case. The court ruled that the enforcement orders were interlocutory based on prior judgments in the same with the same parties, which negated the wife's claim that they were final and thus required leave to appeal. And there was a case of Medlow and Medlow that was cited in regards to that. So this is these are the facts and the issues. The facts were that the case involves the wife seeking leave to appeal enforcement orders requiring her to vacate the former matrimonial home. So she was required to vacate the former matrimonial home, and she wanted to seek leave to appeal those orders. The orders were initially issued to enforce a property transfer, which the wife contested, asserting that the orders were final and beyond the court's jurisdiction. The primary judge extended the compliance time. So, interesting case. You know, she was living in the matrimonial home and thought that she could somehow keep the home or prevent it being sold or prevent her leaving, because there was an order to vacate. So, you know, she's trying to stay in the house. Unfortunately for her, it didn't work out in this case. So if I was to now put this into a flash post, I mean, historically, literally what just happened now would have taken hours to go through the whole case and determine all of these things. Here, it's done in seconds. And we can get this case and all of this information. I can copy that. I can go straight into Flask now and create a new digest. I'm going to just paste that in there. I can go back into the AI and ask it to give me a catchy headline for this case, and create an image that depicts and captures what the case is about. And so it's going straight to creating an image for me. This, I'm just reminding those who are not familiar with it, this is just OpenAI's ChatGPT here. We have got a custom trained model here with Flask AI being the GPT that's been created. But essentially, here we go. Here's the image. I can save that to my system here. And here's my catchy headline. And we can literally publish that post in seconds. And I show you know this process simply because in the past, what I'm showing you now would have taken literally hours to do, and what used to take hours is now done in seconds. And I can go bang, that's all done here. I'm going to attach a header image, which is that one that I've just downloaded. Oops. One I've just downloaded, and there's an image. And you know, later on I can go ahead and share this post with other people. But in the meantime, I'm going to go ahead and publish that one. So that's done, ready to go. And while that's done and ready to go, I'm going to create a new open page for an update. And next step is to go back into where we were and let's have a look at the next case. So the next case here is at the end, 63 paragraphs long, Gillespie and Gillespie. Again, I don't even need to go into reading any of it. I'll go straight to copying the URL. I'm going to go back into the Fast AI GPT. And if any of you want to have access to the Fast AI GPT, just let me know. I'll shoot you a link. But you do have to have a premium membership with OpenAI to access these. Actually, not even that. Recently, OpenAI has made it available to everybody, so you can have access to this. Copy my original prompt. Just cut that. And paste over that and send it off. So, in the past, things used to literally take days to do these kinds of reviews. We would have a paralegal that would sit there and read the case, and then we would have that paralegal write up a digest of it, taking literally days, hours and hours of a person's time is now done in seconds. So the fact this case involves Mr. Gillespie appealing a decision that restricted her from relocating with her children more than 50 kilometres from their school, and a property settlement that did not include debt to her parents as a liability. Okay, so she was claiming that there was a debt to the parents as a liability, and looks like the court didn't accept that, or didn't believe her that debt was genuine, and she was wanting to relocate more than 50 kilometres away. The issues here is, did the judge failed to consider the relevant factors regarding the relocation, and were the reasons for excluding the debt of the appellant's parents from the property settlement adequate? The law that was considered is the Family Law Act with those sections applicable, the Federal Circuit and Family Court of Australia rules, and the relevant case law was a bunch of case law there that was considered. The analysis, the appellant argued that the primary judge didn't adequately assess her circumstances and the advantages of relocating to the city that she wanted. And the court found that the primary judge did consider the relevant factors, such as the impact on the children and the practicality of equal time arrangements. The judge emphasised that the best interest of the children and found that maintaining proximity to both parents was crucial. Exclusion of the debt on that issue, the appellant claimed that the judge failed to explain why the debt to her parents was excluded from the property, but the court determined that the primary judge's decision was within discretion, noting the absence of sufficient evidence to substantiate the debt as a genuine liability. There was no real proof, it was just her word by the look of things. The reasoning for the decision is that the court upheld the primary judge's decision, finding no appealable error in consideration of the children's best interests and practicality of parenting arrangements. The judgment on the property settlement was supported by evidence and appropriate application of legal principles. So the take-home lesson is, when appealing family court decisions, it's crucial to demonstrate clear errors in the application of legal principles and consideration of evidence. The best interest of the children remain paramount, and claims must be substantiated with compelling evidence. We'll move on to the next judgment here and see what that's got in store for us. This is a short one, 27 paragraphs only. Answer and answer. So I'm going to grab that URL there. All right, good to go. Send that off. Let's have a look at the next case. Miss Answer sought leave to appeal procedural orders relating to the disclosure documents in financial proceedings. The respondent, Mr. Answer, required completion of a cybersecurity questionnaire by the applicant and her advisors before providing electronic disclosure, citing concerns over commercial sensitivity and cybersecurity. Oh, interesting. So the issue, whether the procedural orders requiring the CSQ constitute an appealable judgment, and whether the primary judge erred in making procedural orders contingent on completing a CSQ. The law is the Federal Circuit and Family Court of Australia Act. So it's the Act that governs the court itself, Section 7.1 and 26.1, and the rules of the court, Rule 12.17, and some relevant case law here. So analysis, is it an appealable judgment? The court concluded that procedural orders requiring completion of a CSQ were not judgments decisive of substantive rights and hence not appealable. Orders were seen as procedural mechanisms to regulate disclosure. The orders didn't extinguish any legal rights and were subject to variation by the court. Procedural orders and error. The court found no error in the primary judge's discretion to require a cybersecurity measure before electronic disclosure, emphasising the need for security given the sensitive nature of the documents. The appellant's claim is that the CSQ requirements were not mandated by law was insufficient to demonstrate error or substantial injustice. The court ruled that procedural errors for document disclosure do not constitute appealable judgments. Even if considered appealable, the orders were appropriate and no substantial injustice resulted from their enforcement. So the take-home lesson is procedural orders in family law, particularly those ensuring document security, are generally not subject to appeal unless they decisively affect substantive rights. Ensuring cybersecurity in legal proceedings is crucial and within judicial discretion. Pretty interesting case. I think we're going to publish this one. And I guess the interesting thing here is, the court upholds cybersecurity measures. So clearly, there was disclosure that was required in financial proceedings as part of this case. And they required the completion of a cybersecurity questionnaire by the applicant and her advisors before providing the disclosure. So it means that the applicant, wife, former wife, former partner, applicant wife or former partner, and her lawyers had to fill in this questionnaire before providing the disclosure. And this was citing concerns over commercial sensitivity and cybersecurity. So a legitimate thing to ask for, and certainly one that puts I guess just a little bit more pressure on the other side to make sure that they the information that is obtained through this is not going to reach outside of the court. Let's have a look at the next case. All right, this is a 95 paragraph judgment, so quite a lengthy judgment to have to read. Fortunately, we don't really need to do that at this stage. We've just got to go into our GPT, change the URL that we've got here, paste over that, and fire away. That'll give us the information now. Let's see what this one's about. Allwright and Allwright 2024 case. Mrs. Allwright appealed against the primary judge's decision on a contravention proceeding initiated by Mr. Allwright. The proceedings involved alleged breaches of court orders related to both child-related and non-child-related obligations, and the primary judge found Miss Allwright in contravention, placed her on a good behaviour bond, and ordered her to pay costs. And now she's appealing. Okay, let's see how she goes. Issues. whether the primary judge denied Miss Allwright procedural fairness, whether the primary judge erred in applying child-related contravention provisions to non-child-related obligations, and whether the primary judge failed to adequately identify specific contraventions in the orders. The applicable law shows you which sections of the Family Law Act were considered. The Evidence Act was considered as well, and the relevant case law that was considered here. All of the relevant case law is solid precedent there. In analysis, procedural fairness. Miss Allwright claimed procedural unfairness, asserting she was pressured to proceed without legal representation and misunderstood her rights regarding self-incrimination. The appellate court found that the primary judge adequately informed her of her rights and options, including legal aid, and the serious nature of the proceedings. The application of contravention provisions. The primary judge incorrectly applied child-related contravention provisions to non-child-related obligations, confusing the statutory schemes of Parts 8A and Part 7, Division 13A. The appellate court emphasised the need to distinguish between different statutory frameworks for child-related and non-child-related contraventions. The identification, so far it's going good for her as a self-represented litigant. The identification of contraventions, the orders lacked particularity, failing to clearly identify which specific contraventions were found against Miss Allwright. The appellate court stressed the necessity for particularity in both allegations and judicial determination to ensure clarity and procedural fairness. Wow, it looks like she's going to have a win here. The appellate court concluded that the primary judge's errors in procedural fairness, statutory application, and order specificity warranted setting aside the previous orders. The matter was remitted for rehearing before a different judge to ensure a fair and accurate application of the law. Wow, what a huge case. This case is really interesting. Self-represented litigant, and she wins. A win for the underdog. A win, and we'll definitely be publishing this case. And let's have a look at the next case. This one, 119 paragraphs. Hours of fun reading pleasure. Hours and hours of fun reading pleasure. Or we just go in here and I punch in that detail there and go paste, and we go boom, send it off on its way. 119 paragraphs. What's it about? Miss Shipton sought leave to appeal a cost order imposed after she abandoned a disqualification application against the primary judge shortly before the hearing. So she had an application to disqualify the judge. She abandons it and gets hit with a cost order. The primary judge had disclosed a potential conflict, but neither party objected. Wow. So there's a conflict. There's a conflict of interest with the judge. The wife sought leave to appeal a cost order here after she abandoned a disqualification application. The primary judge had disclosed a potential conflict, but neither party objected. Ms. Shipton, later self-represented, alleged apprehended bias, denial of procedural fairness, and legal error in the primary judge's decisions. Wow. Wow. Bombshell. Whether leave to appeal the cost order was necessary? Did she even need to seek leave? Whether the primary judge exhibited apprehended bias or denied procedural fairness? Whether the legal discretionary errors were present in the primary judge's decision? Wow, let's see what happens. Okay, so applicable law. Family Law Act 1975, sections 28 and 117. Well, this is relevant case law. This is in regards to procedural fairness and bias. Ebner is a case you'll hear about often, Webb, John. These are all very common precedent cases that you see in these kinds of decisions. Analysis, leave to appeal. The cost order was interlocutory. Leave to appeal was required. The test for leave involves assessing whether there's substantial doubt and potential injustice. And Medlow is the precedent case for that. Apprehended bias and procedural fairness. The court applied Ebner, identifying the source of bias and establishing a logical connection to feared impartiality. The appellate court found no substantial evidence of bias or procedural unfairness. Shock. The judge's conduct did not display favoritism, and procedural decisions fell well within reasonable judicial discretion. Legal and discretionary errors. The primary judge acted within the legal and discretionary bounds. Decisions on costs and case management were upheld, and given the context and adherence to procedural rules. Let's have a look at the reasoning. This is not going well for the appellant. The appellant court dismissed the application for leave to appeal, citing no errors or unfairness. The primary judge appropriately managed the case and costs without bias or procedural impropriety. The alleged errors didn't meet any threshold for substantial doubt or injustice. And a take-home lesson, challenging judicial decisions requires clear evidence of bias or procedural errors. Courts uphold procedural fairness and judicial discretion unless significant injustice or legal missteps are demonstrated. And there's the full details. Wow, interesting case there. Let's have a look at the next case. That one was an interesting one. Okay, the next case, 134 paragraphs. Oh, gee, in times gone by, that would have taken me like 4 or 5 hours to read and go back over it because it's so complex, the text sometimes. And far away. Boom. Let's see what this one's about. 134 paragraphs. Massive case. Number 5. Jess and Jess have been at it for a while. 5 cases so far, and this one's 134 paragraphs. The wife. Let's see what happens here. The wife, Miss Jess, pursued financial relief against the deceased estate of Mr. Jess Sr. Mr. Jess Sr., so it looks like it's her husband's father, and alleged fraudulent transactions to shield assets from property division. Financial disclosure orders were made, and the respondents sought to appeal these orders and the refusal to stay them. Okay. Whether the primary judge's financial disclosure orders infringed on the respondent's rights to confidentiality. Interesting. Whether the procedural fairness was denied when the respondents were not allowed to amend their defense. Okay. And whether financial disclosure orders required expert valuation opinions beyond the scope intended by the primary judge. Okay. Interesting case. Applicable law. Typical Section 79, property related stuff. Relevant case law, again, Ebner was there for bias, and a couple of other cases were considered, including their previous one, Jess and Jess number 4. Okay, confidentiality. The respondents argued violated their right to confidentiality. The court determined that the confidentiality does not outweigh the legal requirement for full and frank disclosure in family law proceedings. Well, that was pretty much a given there, given that courts can subpoena stuff that's, like medical records and stuff like that. So that was never really going to go up. Procedural fairness. The respondents claim procedural unfairness due to the primary judge's refusal to allow amendments to their defense. The court found no denial of procedural fairness, emphasizing that the fairness of the hearing process is paramount and not the outcome. And the scope of the orders, the court identified that one order requiring valuation opinions extended beyond the primary judge's intentions. It was varied to align with the intended scope. And the reason for the decision, the court upheld the primary judge's decisions, denying the leave to appeal based on insufficient evidence of error or injustice. The procedural aspects were correctly handled, and the confidentiality arguments were outweighed by the need for the disclosure. So what's a take-home lesson? The family law emphasises full disclosure and procedural fairness over confidentiality. Appeals must show clear judicial error or injustice, and procedural fairness concerns focus on the process rather than the outcome. And there's the details of that. What's this one all about? Let's copy that. We'll go straight into the GPT. Another paste, and on its way. Boom. Let's see what this one's about. Scaletta and Scaletta 2024. The facts. Okay, let's have a look. Miss Scaletta, the wife, and Mr. Scaletta, the husband, were involved in a property settlement proceeding. The primary judge awarded 35% of the property to the wife and 65% to the husband. Considering the husband's significant financial contributions, including a business and the matrimonial home, the wife claimed family violence affected her contributions, and the husband appealed, citing procedural unfairness due to his hearing and memory difficulties. Okay. Was there procedural unfairness due to the husband's hearing and memory difficulties during the trial? And did the primary judge err in finding family violence and giving it weight in contribution assessments? So here's the cases that were considered. And Section 79, we're focusing on the property division area. Analysis. Procedural fairness. The husband argued that he couldn't hear adequately during the trial, affecting the fairness of the process. The court reviewed the hearing transcript, noting the husband's ability to understand and respond to most questions despite the difficulties. The primary judge took reasonable steps to ensure fairness, and the husband's legal team did not request additional accommodations. Family violence. The primary judge found 2 incidents of family violence, the Town S incident and the gun incident, which impacted the wife's contributions. The appellate court upheld these findings, emphasising the consistency and credibility of the wife's testimony and the rational basis of the primary judge's conclusions. So the reasoning for the decision is the appellate court dismissed the appeal, finding no procedural unfairness. His hearing wasn't going to be an issue. That wasn't going to be enough to cut it. The findings of the family violence were supported by credible evidence, and the primary judge's conclusions were reasonable. The appellant's grounds lacked merit, and the judgment was fair and legally sound. So he's got nothing in his appeal. Claims of procedural unfairness require clear evidence of substantial impact on the trial's fairness. It's got to be substantial. Credibility findings by the trial judges, especially regarding sensitive issues like family violence, are given significant deference unless glaringly improbable or contrary to compelling evidence. Interesting case. Worthy of publishing? I don't think so. He was just, trying to find a loophole by the look of things here. This is a shorter one. We'll copy that there and fire away. Let's find out what this one's all about. Miss Uta appealed against enforcement and variation of final consent orders. See, consent orders, they're always hard to appeal because you've consented. You know, once you've consented and you've agreed, the court rarely goes over this. But let's see what happens. Dismissal of her contempt application. So Miss Utter appealed against the dismissal of her contempt application. So and the award of indemnity costs against her. So she got hit with costs as well. She didn't have a good day. Consent orders she signed that she wasn't happy with. She's appealed against that and they've been enforced. They dismissed her contempt application and hit her with costs. The final consent orders involved the sale of a property with proceeds divided favourably to her, but she might have wanted the property. Issues arose with arrears of interim spouse maintenance and the husband's conduct as a trustee for the sale. Okay, let's see. Issues. Did the judge err in awarding indemnity costs? Was there a jurisdictional error in the decision? Did the judge fail to consider relevant matters and provide adequate reasons? Was there a substantial miscarriage of justice, including an unjust forgery finding? So, an unjust forgery finding. Should an independent accountant have been appointed? Should the primary judge have ordered subpoenas on its own motion? And were the primary judge's findings and conclusions materially flawed? A lot of things to go over there, but it was a fairly short case, so the judge got... Let's have a look. Indemnity costs. The primary judge's discretionary decision to award costs on an indemnity basis was upheld, aligning with coal and allied operations and House versus the King principles. So, bang, she's hit with costs. No jurisdictional error was found. The primary judge had proper authority to hear the applications. Relevant considerations. The judge considered everything. There was no miscarriage of justice. There was no need to appoint an accountant. The judge is not required to order subpoenas on his own motions. This was just a nightmare case for the wife by the sounds of things. The appellate court dismissed the appeal due to lack of procedural error or injustice. The judgment was legally sound, and again, it's a common case. I'm not going to publish this one. It's just too common. Let's go to the next one. Now, this is a short one, is it? 27 paragraphs. What's this one about? Copy that. There we go. There's the prompt with the URL. Fire away. GPT, tell me all about this. Garrido and Garrido. Miss Garrido initiated proceedings to modify final parenting orders concerning her children due to the father's non-compliance. Okay. The case involved deciding whether proposed consent orders were in the best interest of the children, particularly regarding their time with Mr. Garrido, ensuring their emotional and psychological well-being. Okay. Let's see. Issues: whether the proposed consent orders were in the children's best interest, whether cessation of wise time with Mr. Garrido is justified, and whether the court can delegate future decisions to a single expert. Oh, well, that's interesting. Delegating future decisions to a single expert. Wow. Case law. Lanehart and Allison, 2023 case. This is an interesting one. Best interest of the court emphasised the parenting orders must prioritise the children's best interests. The submissions from the independent children's lawyer and both parents were reviewed to assess the potential impact. The ICL and parents agreed that Y's best interest would be served by ceasing her time with Mr. Garrido temporarily. to allow her to engage with therapeutic supports. The ICL and parents. So it looks like the father's consented because parents is plural. Cessation of wise time with the father. The court evaluated Dr. B's expert evidence, which highlighted the emotional harm experienced due to the father's alienating behaviours. The proposed orders allowed Y to receive necessary therapy without the emotional burden of spending time with the father. Wow. Delegation to a single expert. Initially, proposed orders improperly delegated future decisions to a single expert, contrary to Lanehart and Allison. The court amended this, ensuring that all final determination remained within judicial purview. Reasoning. The court concluded that the consent orders with amendments were in the best interests of the children. The orders allowed the children to live with their mother, ensured X's contact with her father was based on her wishes, and temporarily ceased Y's contact with her father to facilitate therapy. The court emphasised procedural fairness and the necessity of judicial oversight in parenting matters. In family law, the best interests of the children are paramount is the take-home lesson. Courts must ensure that any orders, especially those agreed upon by consent, genuinely serve the interest and maintain judicial oversight. Alright, this is 125 Shams and Al-Chaos. Let's find out what is this one all about. Shams and Al-Chaos. And Al-Chaos. There we go. And we'll send that off on its way. Analysis of Shams and of Al-Chaos. They are disputing the living arrangements of their children, X and Y, following Miss Shams' relocation to Queensland. The children have been living with Mr. Al-Chaos in Melbourne. The case involves determining whether the children should continue living with their father or move to Queensland with their mother. Oh, gee. Yeah, that's a shocking choice to be made. Okay. Should the children live with their father in Melbourne or their mother? That's a tough call now. Are the current living arrangements in the best interest of the children, considering the allegations of family violence and the history of care arrangements? Okay. Section 60B, 60CA, 60CC, relevant case law, a bunch of it that was considered there, including a recent case of Greer and Greer. Okay, let's have a look. Analysis. The children's living arrangements. The court emphasised the importance of the children's best interest as the paramount consideration. The primary judge found that the children have been living with their father in Melbourne without significant issues, and that the father had been the primary caregiver since the mother's relocation. The allegations of family violence by Miss Shams were found to be inconsistent and unsupported by credible evidence. The children's living arrangements. The court emphasised the importance of the children's best interests as the paramount consideration. The primary judge found that the children have been living with their father in Melbourne without significant issues, and that the father had been the primary caregiver since the mother's relocation. So the mother moves to Queensland, the kids stay with the father, no major issues at home with the father, and mum wants the kids to come up to Queensland. The allegations of family violence by Miss Shams were found to be inconsistent and unsupported by credible evidence. Not looking good for the mum in this one. Best interest of the children. The court considered the children's need for stability and continuity in their current environment. The history of care arrangements showed the father's substantial and consistent involvement in their lives. The court dismissed the mother's generalised concerns about the father's care as unsubstantiated and noted her previous consent to similar arrangements. Reasoning. The court ruled that the children's best interests will be served by continuing to live with the father. The father's evidence was found to be credible, and the mother's allegations were not substantiated by facts. The decision balanced the children's need for stability, the history of their care, and the importance of maintaining consistent living environment. Take-home lesson. In family law cases, the best interests of the children are paramount. Allegations must be supported by credible evidence, and the courts will heavily weigh history of care and the need for stability in making decisions in living arrangements. Interesting case. Tandy and Padula is the last one, a 2024 case, ICL involved. You can see there straight away. We're going to copy that link there, go straight into here. Paste that there, give it a space, and good to go. Last case from this review, and let's see what this last one's about. So this is it's been an interesting month in May. Some interesting decisions that we've covered there, and right now we're going to be covering the decision of Tandy and Padula, 2024 decision, May decision in fact. The facts. Mr. Tandy and Miss Padula are involved in a dispute regarding the parenting arrangements for their 8-year-old daughter, X. The ICL appointed to represent X's interests has not been able to meet with her, and the court must decide if it can order Mr. Tandy to facilitate this meeting despite his claims that X refuses to meet the ICL. Wow, interesting case. Does the court have the power to compel the father to facilitate the meeting between the ICL and the child? Well, that would probably be a yes. Should the ICL meet with the child despite the child's expressed refusal? My thoughts, without reading the judgment, is yes. You know, the ICL needs to be able to meet with these kids, and we have too many cases and too many decisions being made where the ICL hasn't even met the child and doesn't know what the child's views are. And yes. And what orders are appropriate to ensure the child's best interests? 8-year-old daughter, you know, an 8-year-old. How can you possibly say that the 8-year-old is going to have, you know, the say over the court? All right. Bunch of case law considered there. All the usual suspects in the sections, and the United Nations Convention on the Rights of a Child, Articles 9 and 12, were considered by the court. Power to compel the meeting. The court has the power under 68L2B and 68B of the Family Law Act to make orders necessary to secure independent representation of the child's interests, including facilitating. So, obviously. ICL meeting despite refusal. The court considered the father's evidence that X did not want to meet the ICL. However, previous interactions suggested X was capable of expressing her views clearly once she felt comfortable. The court emphasized the importance of the ICL meeting with the child to form an independent view. Appropriate orders. The court ordered the father to facilitate the meeting, highlighting the necessity for the ICL to fulfill her statutory obligations and the importance of the child's views being considered in final parenting arrangements. Reasoning. The court determined that the statutory requirements and best practices for the ICL necessitated the meeting with the child, regardless of the child's initial reluctance. Anyone who's listening to this, you've got to remember, this is part of the new rules in place, 2024 rules. You know, previously the ICLs did not have to meet, but now they do. And it was critical for the ICL to form an independent, informed view of the child's best interest, which could not be achieved without direct interaction. Take-home lesson: the best interests of the child are paramount in family law proceedings. Courts can compel parents to facilitate meetings between children and their legal representatives to ensure comprehensive and independent assessments of the children's views and best interest. Wow, that's a really solid case to show what some of the changes are in family law. So we're definitely going to be publishing this case. We'll just go in here and add a new digest. And these digests form part of the FLAST database that later on FLAST AI uses to help people with their questions about family law. Okay, so thank you all for joining me. I hope you enjoyed watching the way I work and put together these digests on FLAST to help keep people informed of the latest developments in family law and keeping your finger on the pulse of the court and how the court will view your case. These digests give you good insights, especially if you're looking for cases that have got similar facts and issues compared to the one that you're dealing with at the moment. Hope you enjoyed the way I showed you how easy and beautiful OpenAI is to use now. With even though this is a custom GPT model, you can do similar things with the regular model. Just jump onto OpenAI, and you've got to pay for a subscribe membership there for that. I think it's $20 a month at OpenAI for that. And reminding you, FLAST AI has got awesome features as well. So. All right, that's a wrap.